Everybody. Okay. Good morning, everybody. Welcome. We have a great program today. I'm Mary D'Ambra, your South Shore Realtors president. So first, a few housekeeping items. This webinar is being recorded. And any questions that you have, you can put into the chat and, we'll try to get to as many as we can. Please be mindful of any discussion that leans towards antitrust. We're all competitors, and so please refrain from discussing any specific business practices or pricing structure. And if you do, we'll have to interrupt you. And if I don't, Catherine Taylor from MAR will. So let's get right to it. Thank you to our panelists for joining us today. And our South Shore Realtors Development Director, Professional Development Director, Marie Souza, is going to post all of our panelists' contact info in the chat. So many of our panelists have Facebook discussion groups, blog posts, or teach continuing ed, or other platforms where you can get more information about the things we'll discuss today. And I highly encourage you to take advantage of their resources for your business that our panelists offer. So let me introduce our panelists. First, we have Massachusetts Association of Realtors Associate Counsel, Attorney Catherine Taylor, who handles the legal hotline at MAR. So if you've called MAR's legal hotline, you've likely already spoken to Catherine. So thank you for joining us. Then we have our South Shore Realtors attorney affiliates. First, we have attorney Mike Baird with Kellum & Kellum, LLC. We have attorney Carla Goodale, Lieberman Law Office, PC. We have attorney Brad Mahoney, Mahoney Law Group. And we have attorney Mark Stiles.
Morning, everybody.
Stiles Law. So we're going to go right into our questions since we have so many. And again, feel free to add any thing that you've got in the chat, and I'll see what I can do to add it in. So first off, we have a lot of questions about multiple offer situations, which we're obviously all dealing with right now. And this one is about, well, here's the question. Is a seller required to formally reject and sign the offers that they are not accepting? Can a buyer agent demand a signed rejection? And what, if any, are the obligations on the part of the listing agent as far as responses to buyer agents and offers? And I'm first going to go to Catherine in case there is any difference between your legal obligations or your code obligations. So Catherine?
Thanks, Mary. That is a great question, and a question I've been hearing a lot of on the legal hotline. And the simple answer is no, there's no requirement that the seller formally reject an offer. Typically, the offer is going to contain a provision in it that says this offer is valid until 5 p.m. on Thursday. And once that 5 p.m. timeline has passed and you haven't had it accepted, it acts as a rejection. So there's no formal action required from the seller. The seller certainly can, but they're not required to. As Mary alluded to, the difference between our Realtor Code of Ethics and the law is in what you as a listing agent may be required to do. If a buyer agent asks you for written confirmation that their client's offer has been submitted, you are obligated under the code to provide that confirmation that the buyer's offer has either been submitted to the seller or that the seller waived the obligation to have that offer presented to them. So that's a pretty big difference that a non-realtor wouldn't be required to respond in any way. That raises the question too of professional courtesy, that if somebody reaches out, obviously from a business standpoint, it might be a good practice to respond to them at the very least, but there's no obligation on the seller to respond.
Okay, good answer. Does anyone have anything, any of the other panelists want to add to that before we go to the next question? Mark?
I think one of the questions that needs to be asked is why wasn't the offer accepted? What can the agents be doing to help their buyer get that offer accepted? And one other point before we move on is to remind everybody that the offer is the contract. We are all following the terms of the offer once the offer is a contract, right? Offer, acceptance, consideration. Once all of those things happen and we have a contract, the attorneys are now stuck with those terms. And you can't renegotiate those terms based on case law in Massachusetts. So it's really important, I think, that all of you know how to get in touch with Catherine's office, right? Brokers have access to Catherine's office. Agents have access to their brokers. Push those questions through, feel comfortable, feel confident, move forward, right? Then get a good contract to the attorneys. I hope that helps.
Well, something you mentioned is part of our next question, which is about consideration. And this question is about the timeliness of delivering or receiving earnest money deposit check. And what does forthwith mean? And is there a valid contract if no check has been delivered? What is consideration? And what is the difference between the MAR and the GREB form in regard to consideration and delivery of the earnest money deposit check? So, Brad, what have you got to say about that? Oh, you're muted.
Sorry about that. So consideration, in law school, we were taught consideration can be a peppercorn or a paperclip. So it can be anything. And the way the contracts are written with the deposit, that's an act in the contract. But I would argue that a mutual promise to perform is consideration. The deposit is listed as having to be in the contracts we have, the purchase and sale, to be delivered with the signing of the purchase and sale agreement. What happens a lot of times is just because of overnight mail, wires might not get out to the next day, the agent didn't drop it off in time. These contracts are mutually executed and then released to everyone. And then we've had situations where that deposit check never arrives. You could argue, I would say you can't argue there was no consideration paid because there's a mutual promise to perform. So that could be the consideration. But I'd argue that the buyer didn't perform under the contract by delivering the deposit, and you could consider them in default. That's my take on it.
And my question becomes, to Brad's point, especially during COVID, what is a reasonable amount of time? Is it 24 hours? Is it 48 hours? I think that the agents are all grappling with what does that look like, because we're not in the age-old time of we print out 4 hard copies, we go to our client's house, they sign all of them, we go meet the agent, deliver 4 copies, deliver a check. So, and maybe Catherine could tell us, like I said, especially now COVID's going away, whatever we want to say about that, but that offices weren't open to go drop a check, or there might not be an overnight drop box, or there might be, you're in Wareham and someone in Peabody is buying. So what is a timeline that the brokers can tell their agents is acceptable? Although we do have a mutual consideration, house came off the market. So that was another, consideration that it came off the market and everything, to say that if we don't have it in 24 hours, 48 hours, what is it before this deal could be considered void?
Catherine, if you could speak a little more to that, and also from your previous discussion about the rejected offers, et cetera, someone in the chat asked a follow-up question and says, so legally the seller doesn't have to sign a rejected offer, but
Correct.
Code of Ethics requires us to provide one. I think they misunderstood in
Right.
or waiver. So could you reiterate that and then?
Yeah, the code places the requirement on the listing agent, the realtor involved in representing the seller. It doesn't place an obligation on your client, the seller themselves, to sign the rejection. So you as the listing agent would then be obligated upon request to provide some writing. It could be an email that says, yes, I presented buyer A's offer to my seller, or my seller waived the obligation to have offers under $300,000 presented to them, so I did not present your offer. If that was an instruction that you received from your client, that would be lawful as well. But that obligation rests squarely on the shoulders of the agent involved in the transaction, not the parties to the transaction itself.
Thank you.
So with regard to the second question, I'm not going to belabor the point, but there's just a little bit that I do want to add with regard to the MAR contract to purchase. It does specifically call for the remittance of a deposit to bind the offer. So, and then there's those two options. There's the check is submitted herewith, meaning it's enclosed with the offer upon presentation, or it will be submitted forthwith upon acceptance. And then we get into that whole conversation of what does forthwith mean. And that's sort of it's not a precisely defined term because it could vary depending on the circumstances. So take COVID, for example. It turned our industry on its head. And what is forthwith under these circumstances may be a little different. So it's really as soon as it can reasonably be provided. What does reasonably mean in the situation you're dealing with? So our contract specifically calls for that deposit. And if that deposit's not received, then you have a question of whether that contract was ever actually formed. If the contract doesn't say that the binder is required to form the contract, then you get into that conversation of, well, the mutual exchange of promises is sufficient consideration. And now are you in breach of that contract, which then gives you the ability to cure it before the contract is voidable potentially. So it really depends on the specific language of the contract you're using.
Thank you.
Mary, just one thing, just to, not to belabor, but just one thing. I just think it's good practice for agents, the listing agent, not to release the purchase and sale. And again, Catherine talked about the offer side, but on the purchase and sale side, I think it's a good practice not to release the purchase and sale as the listing agent until you have the deposit funds. Just wanted to add that.
Can I just reiterate that all broker managers, branch office managers are writing down Catherine's information. This is available to you all. And I have a question, a challenge. Who's going to take in the first earnest money deposit in crypto?
Not me.
I can't wait to do a crypto
Venmo,
closing.
maybe, if it's small. All right, this question came on the chat, and okay, Mike, I'm going to ask this to you first, but this is a good question. So, okay, I just saw a listing where the seller's agent wants the buyer agent to fill out a form with an offer submission. This isn't an auction or a foreclosure, straight sale. Am I obligated to do this? I'm concerned that this form does not have the nuances of my offer, and those nuances will be missed if the form is presented and negotiated on instead of the offer. Do I have to abide by the agent's instructions? Good question.
So just to clarify, the listing agent is required a certain form be filled out?
Yeah, I've seen this myself. So, they say offer instructions attached, and they've got attached to the offer, they've got a form that they've created. So the listing agent has created a form, and they're requiring you as a buyer agent to submit this form with your offer. And it's, sort of a summary of some of the details of the offer. So this person is saying that they have concerns about that because, this little info form isn't the full offer, and it may be losing some of the flavor of their offer. And they want to know, are they required to use that form if the listing agent says so?
Yeah, that's a good question. And good morning, everyone. Thanks for joining us here. When I have seen those other forms. My knee-jerk thought is to say that you're not required to fill that in, but required by whom to do what, right? If you put forward a standard offer, the legal terms of that offer are pretty well established, and you've made a formal offer. So, but is the listing agent basically say they won't present your offer to the seller unless you fill in, this form? I then fall back on the all too traditional attorney position is it depends. It depends on what's in the form. Are they asking for, things that would violate fair housing? Are they asking for, different things that would impact your ability to obtain financing, where you're moving from, outside of the regular realm of a pre-approval, or what's going to appear in the offer forms with respect to your financing. My knee-jerk thought is to say that you can ignore the form. Most of those forms that I've seen that people have sent to me, like, hey, the listing agent or the buyer's agent wants me to fill this in, do I need to? I usually say, no, that stuff is contained in a standard offer. But if the listing agent is requiring it, probably, the listing agent may be simply requiring it for ease on their end for administrative purposes. If they're, plugging in information somewhere, or it's just
I would say that likely that is why they're requiring it, because it makes it easier for them to, organize, the data of these multiple offers. But I do understand that, this person's question, they want their offer submitted, not just this informational sheet. Doesn't.
So I guess depending on the information the form is looking for, it might not be inherently bad, but as a buyer's agent, if you're issuing this, what's the standard, the standard offer, the standard information, I think you have pretty solid grounds if your offer then isn't presented to that seller. And then even as the listing agent, are you providing the service you need to be to your, to your seller if you're saying, well, they didn't fill out my administration form, so I didn't present you with that offer. That might be a problematic conversation that the listing agent has with their, with their seller. I don't know how thorough of an answer that is, but I'm trying to be about it.
I get it. Does anyone else have any comments on that? Has anyone been seeing that as a Mark?
It goes back to my initial, question is, why are these people not getting their offers accepted, right? There's a lot of offers being presented to a seller. Why are you not putting your best foot forward? Legally speaking, okay, do you have to do it? Probably not. But if the seller wants you to do it, are you going to do it? Yeah, you're going to do it. And it's probably because you're putting in your loan information, right? Who is your lender? Can we contact your lender? Because your lender, if you have a good relationship with them as a referral partner, they're supposed to be calling the listing agents anyhow, saying, hey, I got a good buyer here with a great agent. It's going to be awesome. Go with them.
So basically, you're saying that it's not required, but in this environment, we're all doing a lot of things that may not be required, but we're just trying to, represent our buyers to the best of our ability. Make sure you're not violating any fair housing when you're filling anything out, but maybe also to ensure, that your offer is actually being submitted and not just this information sheet.
Unless it's some really probing questions that the that the buyer really doesn't want to share, it's not horrible to just do business the way business is being done. If this is what the seller is asking for, and like I said, there's nothing problematic in the form, legally might not have an issue.
Well, let's move into one of our favorite topics of late, which is fair housing. and love letters. So, okay, the first question is how to handle co-brokes or buyers who are asking about neighbors, or, sometimes sellers, personal kinds of information, and suggesting that the listing agent is required to disclose this information. So this question is asking for suggestions in how to handle those kinds of questions. So who wants to answer this? Catherine.
I will start with this one. I feel like I should record my answer. I've been answering these questions so frequently. So the bottom line that I tell people when you receive these types of questions is be the source of the source. This isn't information that you necessarily want to be disclosing, and you're certainly not obligated to disclose neighborhood information. So if they're asking for crime statistics or demographic information, direct them to where they can obtain that information on your own. If you're providing that information, you're potentially placing yourself at risk of a fair housing violation or potentially defamation, depending on what it is that you're saying, right? If you say, oh, that neighbor next door, oh my gosh, they throw parties all the time and they're obnoxious, and it's really the neighbor on the other side, you potentially just defamed somebody and could be subjecting yourself to litigation. So you don't want to be giving more information than you're legally required to. And typically things outside of the four corners of the property that you are actively selling aren't required to be disclosed outside of a few very narrow situations. But neighbors never fall in that. It's usually things that are rooted in the ground. So things like groundwater contamination would need to be, but noisy neighbors wouldn't be. So be the source of the source, but don't divulge that information if you don't otherwise need to.
Sounds good. And okay, love letters. So I guess we could take up our whole time talking about love letters, but let's not do that. So just kind of focusing on why are love letters discouraged? What are the options for a listing agent regarding how to handle love letters? And then I think, one of the questions is really important right now. Buyer agents, what can they do? What are their options when they're competing for, the small inventory that we have and everybody else is writing letters? This has been a question that's been asked, I've heard several times where, a buyer agent is trying to get away from writing, and these kinds of having their client write these kinds of letters, but they don't want to be seen as not doing everything they possibly can to, be the one who gets the accepted offer. Carla, I know you have something to say about this.
I do. I have a lot, and I'll make it quick. So first of all, I think that you need to start out when you're taking the listing as a listing agent, set the expectation with the seller. Tell them about these love letters, and let's have a conversation first about, are we going to accept them? Are we ever going to look at them? From there, you need to set the expectation in MLS correctly. There's a lot of expectations that can be set in MLS that I feel would take up problems out of this if it were that if an offer is presented, you have to present the offer. But the problem becomes is everybody's love letter sounds the same. Best house, been looking forever, going to treat it, da, 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 da. Then we come into the fair housing. I'm originally from X. Okay, now you're a foreign national. I have this many children. Oh, now we've got familial status. I'm a same-sex couple. Oh, now we have a problem. You just go down the line of all the ways that someone could potentially sue a seller because you didn't accept my offer because you judged me on this letter. So I think, and I'm not the first person who said this, so I can't take it, is how about an agent love letter? These buyers are qualified. Here's their loan officer. Here's their name, email, address. They're expecting your call. Here's the attorney. Here's the contact information. Here's the home inspector. We have already reserved 3 different times. Here's this, here's that. Make it on a gold platter with a silver spoon and everything else like that. Hey, listing agent, I'm the buyer's agent that is going to make your life so easy. And my team is going to make this so easy. You are going to be thrilled that you accepted our offer. Because I have someone from about 2 years ago who is still trying to sue the buyer because they wrote this beautiful love letter. We're going to treat your house just like you, 40 years, your children, we want to raise your children. Old lady who drives by 2 weeks later, house was leveled. And she's like, they lied to me. And I was like, what, sort of thing. And so I think that, we all know it's not just price. The average person is not, only 1% of the Americans are only based upon price-driven, consideration. So what is it? It's the terms. Is there a use in occupancy? Is there a this? Is there a that? What is it? So it's not just terms. And when I teach my agents about, call the listing agent first, find out, what are you looking for? What is, and again, maybe you put in an MLS. Sellers are looking for a 59-day use in occupancy, something like, set forth what you think is the pristine offer, because then listing agents tell me, well, I can't quarterback 100 phone calls in between my open house and when offers are accepted. So I think that it's getting to what is going to motivate the seller most and getting that on paper first. And then again, if you've set the expectations with the sellers first, we're going to look at all the offers. We're going to talk about the pros, the cons. And I will say this right now, agents, please send your pre-approval to your attorneys. That actually helps us when we're drafting the P&S and editing the P&S and stuff like that, knowing what's going on in the pre-approval, is it FHA, is it VA and everything? Because agents will come back sometimes and go, well, we didn't agree to that. And I said, you did agree to it because it was in the pre-approval, and the pre-approval was part of the package. So, look at the entire package. And if it really comes down to, gosh, we just can't decide, maybe then you go and grab the letter and say, okay, now that we've looked at everything, here are the 2 letters, or this one has a letter, or this one doesn't have a letter. But again, if you set the expectation correctly with the seller about these letters may or may not be true, these letters could potentially open you up to some liability if you don't choose that offer, then, you've already had the conversation and you're not just going, oh, here's the sob story. This is the one that we need to accept.
Good answer. Good suggestions too, which I like. Does anyone have anything really important to add to the love letter discussion?
Just one very quick thing, Carla, that was a perfect answer. I love everything that you just said. The one thing I like to highlight when I talk to people about love letters is this whole conversation that we've been having for the past year about implicit bias. Is you don't have to be consciously using that information for it to be a fair housing violation. We all have unconscious biases that we try to not use, but they do come in. It's human nature. So the more you can do to shield yourself and shield your clients from even having that potentially seep in, the better off you are. There's no malice required. There's no intentionality required, but it can still happen. So our bottom line recommendation is to not ever accept love letters or engage in passing the love letters at all.
Can I add on to that, Mary?
Sure.
It's so environmental right now, the market with supply and demand the way it is. I mean, we've said to clients selling, if you've got a problem, title, encroachment, whatever, sell it now. This is a great time to be selling that house because people will take a crackling foundation. But I used to love letters. In fact, I am publicly, recorded saying, you know what, forget love letters, do a video of how great this is, because I never thought people would, be jerks, right? Would be implicitly biased, what have you. Ignorant, I am. But Carla, tremendous idea. I'm going to steal it. I'm going to tell all our referral partners to do it.
That's what we're here for.
Agent to agent love letter, right? It's here's what's going to happen. Here's the journey that you're going to experience with me versus somebody who's not even calling you, somebody whose lender's not calling you, somebody who's throwing an offer in there and hoping and sitting on Hope Island wondering why their offer wasn't accepted, because it's not always money. How's the experience going to be for my people? Are you going to give them everything they need? Because market says you kind of have to. So fill out the form, help us out, do what we're asking you to do, and, figure out the lawsuits later. Right, Catherine? Just kidding.
There's a follow-up question in the chat to this, which is basically just looking for guidance on how to word sorry, within MLS. So basically, you know, along the lines of, you know, the seller will not read personal letters from buyers or some such type of a thing. They're looking for guidance on how that could be worded properly in MLS. Anyone, Mike?
I mean, I think it can be pretty simple. You can say, like so-called love letters will not be read by seller, or will, seller not accepting personal statements or something to that effect. I feel like it can be a pretty simple MLS one sentence.
Just one sentence.
I mean,
Yeah.
that's my knee-jerk thought. Yeah.
All right.
I would agree, and just make it as clear as possible. Say personal buyer letters will not be presented. So then if you receive an offer that contains a letter anyways, you can turn it right back around to buyer agent and say, as per my instruction in MLS, my seller's not accepting this. Please submit a clean offer. And then you don't even have to have your eyes on that, because the second you look at that love letter, if it contains personal characteristics that place them in a protected class, you can't unring that bell. How do you prove that you didn't use that information?
Right.
If you have that instruction, you can turn it right back around and say, I'm not even opening and I'm not even looking at it. Submit me a clean offer. That puts you in a good risk management position.
All right. Let's go back just for one question, which is about the earnest money deposit. A question about the legal status of a copy of a check submitted with an offer. Can it be scanned and deposited? You're all shaking your head no, but
Can a copy of a check be?
so if an agent, yeah, so they're asking if, we pretty much all use remote deposit these days, right? I mean, I don't think anybody actually physically goes to the bank with a check. So they're asking, could a copy of a check be deposited?
I don't believe so. I think the law is, and you guys can chime in on this. I think the law is similar to the electronic recording law, where you have to have the original in your hand.
Okay, so if somebody did that, it would not be kosher. Okay.
I think the other thing you have to be aware of is oftentimes when these, pictures of checks are being sent, they have the account number redacted, which makes it even more worthless because it doesn't provide you any information. It's just a picture of something that you don't even have the account number for. But then if it's not redacted, you need to make sure that you're complying with WIS policies and protecting that personal information and not sending it in an unsecured manner, because then you're potentially placing your client's financial solvency at risk by sharing that information. So I wouldn't recommend that practice.
I guess I would ask to clarify the question was, does the question actually mean when they fax it over, they email, scan it over, they're saying, hey, look, we have a check, we're good to go. Does that constitute delivery of the EMD? If that's the question, I would say no. But it certainly is a practical good faith to say, hey, we're coming over, we'll be bringing it, but that's where I can't wait till people get to shoot the crypto over. Boom, instantaneous, we're in, we got a deal.
I mean, I think what I've heard of myself is what Catherine had spoken to earlier, and I think Brad, you've got an offer, it's accepted, now you're waiting for the check. I've heard of the copy being scanned, and yes, the numbers should be redacted, but I think I can say pretty confidently that I get offers all the time where they're not. And so I think that's where this question came from. Like, is that allowed? I mean, if a buyer said, oh, my check is lost in the mail, yeah, if they gave you permission. But I think what Mike is saying is no, you've got to have the original, right? And that's
my argument is you have to have
make a
funds
deposit.
that can be.
For it to be good funds, I'm sorry, Brad. I mean, to make a deposit, for it to be considered good funds, I would say you have to have the original in your hand. Sorry, Brad, go ahead.
No, I was going to say the same thing. I mean, I understand the copy of the check supplementing the offer, obviously taking into account privacy concerns, is just showing, yes, my client's got, I'm holding the check, I have it, I'll deliver it. But that is not conveyable money until you actually have the check that can be deposited.
Can I
And
just
then,
say,
people say, there's deposit link, not to advertise somebody else's company. There's deposit link that a lot of companies use, which is pretty helpful, I think, because it's instantaneous. It can all be done online. There's wires, but then that brings in the whole concern, which is another topic for another time, of the wire fraud and the concerns with that. So.
Well, I think, and Mark, you hit on this. I mean, it is 2021 and we're doing everything electronically and pretty much accept that, right? Except the exchange of money. So hopefully that will change and some of these problems will go away.
can I just clarify the term
Oh,
good,
yeah.
good funds was utilized right there. And there's a good fund statute, which a lot of the broker owners understand, is you can't go to record in a purchase money mortgage without so-called good funds. So, the earnest money deposit, it's a fluid conversation. It's in transit a lot, right? But if you need the breach, you may have the breach, right? So again, I can't reiterate for those who are coming on later to get with your brokers to make sure that you can get with Catherine at MAR in their legal hotline, because it's so important to have that. If I were asked, I was preparing for this the other day and I asked myself, if I was a broker, manager, owner, what would I be thinking about right now, right? Liability, cyber,
Sure.
Brad, you touched on this, Brad. Cyber security, right? Is someone going to move money out of our accounts accidentally? Do we have insurance for that? And does everybody have the proper E&O coverage and access to answers, right? Whether it's your referral partners, your attorney partners, those folks that are helping you with your business, or that direct line to basically what we would have in our office as an underwriter, right? So we don't have all the answers. We have to go and seek answers on title, and we have title insurance underwriters. These are folks that we lean on in our business every single day. Access to these folks at MAR, I would love to have that. That would be my number one goal for the year, is to make sure that we're right in there with them. Cyber insurance is paid up, E&O is all squared away.
Hey, Mary.
Sorry.
We go to a question over here that talks about, and maybe I'm jumping the gun here, about, running title and showing up late and everything else like that, because I love the question, but I think that there's some misinformation out there about what's going on. So I would like to address it.
Yeah, sure. So let me find the question. We've seen an issue on the buy side with attorneys running title late and issues showing up late. Is there a way to get title done early so this doesn't happen? That's what you're referring to, right, Carla?
It is, and I'll start it, and I'm sure
Okay,
the
great.
gentlemen here all have something to say. So it's not usually about us running it late. It's like everyone else. There's only so many title examiners out there, just like appraisers, just like everything else like that. So, if I know a deal's going forward, I'm ordering title before the P&S is even done. Like, as long as I know it's going forward. So the question becomes, is if you as a selling side want to make sure that there are absolutely no issues on your property, because again, let's remember there's COVID, bankruptcy courts, probate courts, like I can't get probate sometimes, things like that. And I know it was before COVID, but COVID has not helped the situation. Is that you really want to make sure, well, then your seller should reach out to the attorney that they're going to use and say, will you please run title on my property now, at least 50 years or two bona fide owners. So not from mother to son, back to mother, to the trust, to the, at least 50 years. You want to find out that there's no missing discharge out of a bank that doesn't exist, or your remainder man, you can't get the property because your trust was wrong and this and that, or you have a son in places unknown that somehow needs to, or they've left the country, or this, that. You want to make sure, sellers, that you can close on the day that you want to close. Well, then you need to do that. Is there an expense to that? There is. It's a couple $100. You can get it. So when you start talking with the listing agent, sellers, you should have already chosen your attorney. And yes, especially in this market, you should have an attorney. Not that I don't need an attorney. You should have an attorney. That attorney should run title then, make sure that there are no title issues, make sure that everyone who needs to be included in signing things is in a place that they can be, that the originals can be obtained and everything else like that. Then you'll know 99.9% of the time. Yes, every once in a blue moon, an attorney and their title insurance company might go, you know what, we actually don't like how this was solved or something. But it takes the majority of the problems that you might face as a seller out. And you're right, every once in a while, someone does run title late, or they don't get around to looking at it. And when they actually review it, they're like, oh, there was a problem here that my examiner didn't really anticipate was going to be the problem that it was. But again, as we're relying on our title companies, you know, if I call up any of my 4 title companies, I might not get an answer in 15 minutes. I might not get an answer for 2 days. They're equally as jammed up with all of these problems. So the moral to the story is, if you want to make sure your seller has no problem selling, then they should pay for a title exam before you ever put that property on the market.
Yep. And that's an excellent point, but also it speaks to the timeliness of these deals, you know, as they're coming together. Again, you're trying to stand out as a buyer, and you're saying, well, you know, and you have a loan officer on the phone that wants to get referrals from the buyer's agent who says, I can get this loan done in 3 weeks, no problem. And you say, okay, well, let's close in, you know, 30 days. And then all of a sudden you've got a week to do your inspection and get your purchase and sale together. And now suddenly you've got 3 weeks to get your financing and your title stuff done. And so typical title exam can take 10 days to 2 weeks, and now you're a week before closing. So what now is perceived as, you know, the last minute, a week prior to closing, is actually within the realm of reality. But that conversation could have happened, you know, at the dining room table when you were putting that offer together, just in terms of the general time frame. But absolutely, yeah, it's definitely good practice for a seller's attorney to take a look at the title as well.
And to follow up, Chris was asking what you can do from the buy side. Chris, until you know that you're buying a house, I mean, are you going to order a title exam 3 weeks before a house goes on the market? I mean, the house is going on the market on Thursday. Sometimes sight unseen, it's under agreement Friday. There's no way that you can do title exams on every single house. So really, it would be good practice if the selling side's doing it. But from the buy side, Chris, there's nothing you can do about it.
Also keep in mind that, you know, it's not the seller's attorney's opinion that matters in that regard. I mean, we pretty much all operate under the same rules, but like Carla said, you know, what I think is fine, you know, Brad's underwriter over at Caddick, you know, may not like or whatever. So yeah, but I think it speaks also to the timeliness of the turnaround that we're trying to deal with.
And I just add something that Carla had mentioned with respect to buyers looking to, you know, analysis paralysis, right? I got to make sure there's no liens on the property before I put an offer in, right? That's going to be the #1 out that you'll ever have in any transaction is title, right? You can get out because of title. But we also have in the past and are starting to get questions about running title in advance of a foreclosure, of which we're about to see a lot of, unfortunately. And I always tell my investor clients, just make sure it's first lien position, find out what the taxes are, condo fees, and if there's outstanding water. Other than that, everything's getting blown up. Make sure it's a first lien foreclosure, and we'll do title after. We'll make sure the foreclosure is done properly after, but don't get me running around doing really complex titles and then you don't even get it at foreclosure. But investors are going to be a big part of the next 24 months. So be ready for those folks too.
Okay, I want to go back to the check discussion just because there's a couple of, you know, just to close out these questions in the chat. So, okay, we're talking about the earnest money deposit check. And someone's saying if a copy of a check is not acceptable, which that's not what we're saying. But he's saying if a copy of a check is not acceptable when emailing an offer, does that mean you have to hand deliver the offer with check? So we're saying no, you can email a copy of the check with the offer and you should redact the account number. So then it's going on to talking about online deposit companies where you can e-deposit checks, you know, deposit link, et cetera. And saying that, you know, I can't see why a copy of a check front and back couldn't be e-deposited if necessary. And I think the original question was, can that be done? Yes. Should you do it? I think you all were saying no.
No, I just, sorry, Mary, my understanding of banking, I mean, we do everything remotely. We can't take a copy of a check and scan it, and that's fraud. We have to have the original check. But I saw that on the sideline. I understand the practice of showing, here's a copy of my buyer's $1,000 to bind the offer. I have it. That's not money that can be deposited. What that's a promise to deliver the money once the offer is accepted. If that check bounces, then you could argue, well, you haven't even given me an earnest money deposit. So I think the practice you guys have is good. Hey, here's my $1,000. Redact, and I'm going to give it to you once you accept it. No one's saying you, with your offer, have to give the original check and, oh, please accept my offer. That's not what we're saying, but we're saying that picture, scan, fax, whatever, is not money that can be deposited into a bank account.
Yep. And I think that practice is the same for when the purchase and sale agreement gets signed, because we were talking before about timeliness of delivery of the ultimate EMD, and that practice is the same. Yeah, I have a copy of it, I'm bringing it to you now, but you can't deposit that copy.
Okay. Let's move on to home inspection. So that's been a really hot topic lately too. And here were some of the questions that came in ahead of time. What is home inspection is for informational purposes only? If a buyer asks for a repair after home inspection, does that negate the offer contract? Is there an MAR form for buyer to sign if they choose to waive home inspection contingency? And if a buyer waives home inspection, closes on the property, and then discovers issues post-closing, do they have any recourse? So those are just some of the questions. There's probably going to be more, but Catherine, why don't you start, because you can answer whether there is an MAR form for a buyer requesting to waive their home inspection.
Sure.
Contingency.
We'll try to remember all of those questions.
I can repeat them, but just
all of them. There is not currently an MAR form specific to a client who's waiving their home inspection. That can be a conversation you have with your client, go over the pros and cons of a home inspection waiver, and ultimately the decision needs to be coming from your client. You should not be dictating that decision. It's not a one size fits all. Their first time home buyer, you should probably be discouraging from waiving their home inspection, even though that might give them, a competitive advantage in this offer, because they're novices at the process. If it's somebody who's an investor who's bought 45 properties in their life, it's a little less risky for them to do. And you can go over the pros and cons of that type of thing and ultimately let them make that decision, and always memorialize that in some sort of writing. It doesn't necessarily have to be a form per se. So if you have a conversation with them, either face-to-face or on the telephone, follow up with an email and say, dear Mr. Smith, as per our conversation this afternoon, we covered the pros and cons of waiving your home inspection. You have counseled me at this point that you'd like to waive your home inspection. If my understanding is incorrect, please let me know. And then you have a contemporaneous writing that documents that conversation. And then, you have something to point to it. If there ever is a question about the sequence of events that happened that led to the ultimate waiver of that home inspection. You also have to provide your clients the fact sheet for a home inspection. So that can be part of that same conversation, because you're already required to be providing that. So as part of that conversation, you can incorporate that. Inspections for informational purposes only has been one of those phrases that has gotten tossed around with abundance over the last several months. And I think that you're going to get a different answer from every person you ask what that means. My recommendation when I hear that phrase is it means nothing. You need to include more specificity, because when is that inspection going to happen? What does it allow the buyer to do or not to do? And that's something that, again, you should be counseling them as to the pros and cons of that type of thing. If your seller says, nope, they waived their home inspection, that means they're not entitled to access at all, ever. There's no requirement to do that. If it says for informational purposes only, Well, oftentimes the buyer may still say, well, depositing my initial or forfeiting my initial deposit is worth it to have that information because, you know, there's a crack in the foundation and that's going to cost me a lot more, and they're still going to back out. So it doesn't really change the scenario there. If you wait until to allow that information only purpose inspection until after the purchase and sale agreement, then they have a little more skin in the game. There's a little more on the line if they decide to back out after that information only inspection. So you can always negotiate that, but if you receive an offer that simply says home inspection for informational purposes only, you should be countering with more specific language so that there's a meeting of the minds as to what that means and what the obligations are of each party involved there. I think the other question was about whether somebody wants to negotiate after an inspection. That doesn't negate the contract. There's no obligation to negotiate unless the buyer is leaning into the language in the contract, the standard inspection contingency language that says buyer on or before X date can back out of the transaction, you know, at their discretion based on the results of the home inspection, unless they're triggering that language. And they say, hey, you know, our inspection turned up these things. Would you be willing to repair them? Would you be willing to give us a credit for X amount? That's part of an ongoing negotiation. It doesn't necessarily negate the contract itself unless the buyer is signaling, nope, I'm backing out as a result of this. That doesn't obligate the seller to do anything unless there's contractual language that says they'll repair up to X amount or whatever situation. So that's where that contract language becomes really, really important as to how to proceed in those situations.
Mark?
Can I ask Catherine a question? So this has been really bothersome for me because people who have come to our school have heard me say over and over again, I'm not for regulation, but here's a consumer protection device that I would like to see instituted in Massachusetts, and that's a mandatory home inspection. And, you know, people kind of hem and haw, but wow, would it eliminate these conversations? I have a question though, which is, what does it look like legally if the seller pre-listing does a home inspection and delivers it as part of their offering package?
Yeah, that's a really interesting question. I'm glad you brought that up because I've had several discussions on that exact issue. Again, it needs to be coming from the seller. So in this marketplace where a lot of buyers are thinking in order to give themselves a competitive edge, they need to waive that home inspection, but then they're going in a little bit blind, which is really scary. And then from a risk management standpoint, if you close on the property and 2 days later, the water heater explodes, that buyer is going to come back to somebody with their hand out and saying, you know, I deserve something for this because I just bought the house and this shouldn't have happened. So how do you protect yourself and your seller against that? Part of the conversation could be having a pre-listing inspection. The risk with a pre-listing inspection is that you could potentially uncover issues that you were not previously aware of, and now you have a disclosure obligation, which may not have existed previously. Massachusetts has such a low threshold for required disclosures that you're opening yourself up to a hardier disclosure obligation that you might not otherwise have. That's not to say that's a bad thing. You know, I'm a fan of transparency personally. I think that it benefits everybody when, you know, there's more information and everybody is operating on the same page. But ultimately that decision needs to come from the seller because it exceeds the legal obligation. So if the seller is saying, yeah, I think that's a great idea, then absolutely do it. But don't have that as part of your office policy that you say, we do pre-listing inspections, because then you're getting into that area of, are you truly acting in your fiduciary duties for your seller by obligating them to disclose things that they may not otherwise have to disclose? And then from that, you know, liability post-closing question is, if they waive an inspection, unless there was active misrepresentation on the part of the seller or the agent failed to disclose something that they were obligated under 93A to disclose, it's going to be hard to find liability for a situation where the water heater explodes, whatever the situation is. However, that doesn't stop somebody from trying to get that money from you. So there might still be a situation where they, where you may have to incur legal fees to defend yourself against that type of thing, but the imposition of liability is probably relatively minimal. However, I will say in the marketplace we're in right now, where things are flying this way and that way, talk to me in a couple months and let's see where things are shaking out and see what happens, because there might be situations that arise.
That's kind of my point though, right? Why don't we figure it out before the couple of months and when everyone starts fighting over it, right? As we said at the beginning of this workshop, show, whatever we're doing here, educational platform, put it out there. If you've got a problem with your house, put it out there. And what better way? I'm assuming that legally you can't attach the home inspector, because he's that person, that company who's inspecting is certifying to the homeowner, but yet you're still disclosing everything. So 2 years from now, 2 months from now, when the water heater explodes, it's kind of like, well, I mean, if you had read it, right, it said here it was 17 years old, right? I assumed your offer price to purchase my home was reviewed thoroughly. I have one more question for you, Catherine, and that's with respect to as is. So there's some competing thought on, as is in a purchase and sale agreement is a page long and it talks about everything, buyer beware, caveat emptor, neighbors, everything. If that is not negotiated, is that kind of ignored as in the eyes of the court?
So if a property is listed as is, it simply means it's the seller signaling that they're not going to give you any credit or make any repairs to the property prior to closing. Doesn't necessarily mean the buyer doesn't get to have an inspection, unless that inspection is waived. Did that answer your question?
No, it's more about the language that our community as a group collaboratively, I hate to use competitors, more counterparties, cooperators are working through these purchase and sale agreements where buyer wants to buy, seller wants to sell. This as is language, right? I mean, obviously the seller wants to not be held liable past here. How can they, make sure that the buyer fully knowingly understands that they can't come back to the seller? You're buying pimples, warts, all of it, right? Then we put this as is language in, but if it's not negotiated, is it kind of adhesive? Or is it kind of ignored by the eyes of the court because it was not understood? But once you start to negotiate it, it becomes part of the contract. I think there was a case that recently came down on this.
I'm not sure about a recent case on that.
Okay.
It doesn't mean it doesn't exist, but I'm not aware of it. But I would say, so even if in your listing it says as is, I would always carry that language through in the contracts for exactly the reason you just highlighted. So there is a true understanding of everybody involved in the transaction of how that property is being sold and what the obligations are.
Well, there was one point, okay, Brad, maybe you can answer this, because one of the questions was, there was no home inspection, the closing happened, the buyer's living in the property, and now there's some defect they've uncovered. Any recourse?
Well, I just want to jump back to the informational purposes only, and then I'll answer that. So we see that in so many offers, and you could argue it both ways. My suggestion, and what I think most buyers and buyers agents mean by that, I think, is that we are going to do an inspection. If we don't like it, we're not going to renegotiate, but we have the right to cancel and get our deposit back. That's what I think most people mean. So what I say to clients and agents is, put in inspection is for informational purposes only. We will not renegotiate the price, but we retain the right to cancel the agreement. And if that's what you really, it just makes it simple. That's what you mean. Everyone understands, instead of usually offer deposits are 1,000. With this market, I'm seeing 10,000 is pretty common. We're getting into arguments over, well, yeah, you can do an inspection, but you can't cancel. And if you do, I keep your deposit. So we're going to argue over $1,000 and get a Liz pendants and all that stuff. Just again, 99% of the time, I really do think it's informational purposes only. The buyer thinks, I'm getting an inspection, I'm not going to nickel and dime you, but I can walk. So just make it clear in the offer. In terms of after the fact, Mark touches on it, Catherine touched on it, as is language, if you have a decent attorney, even if you have a poor attorney, it should be in there. It's prevalent in our contracts on the seller side in the riders that most attorneys in our area, in our community use. And it's very clear that you've either waived your inspection rights or you've had an inspection and you're accepting the property as is with all defects as the time of the closing. And that goes for zoning, it goes for use, it goes for any other myriad of things. So I just think any argument, absent material omission, material misrepresentation, I think you're gonna have a really hard time. It doesn't mean you can't try to sue somebody or you can't be sued, but I think that as is language, absent fraud, is going to hold the day, and you own it, you own the problems. So just keep that in mind. That's my take on it, and I think that's kind of how it's held up most of the time. One other thing I saw somebody mention, and I don't know if it's in MAR, but I know it's in the G-Bar's offers. Radon, they asked a question about, is radon different than the actual home inspection? Yeah, I know in G-Bar's offers, radon is actually a separate inspection checkoff as part of their contingencies. So I've had some situations recently where they put a cap on there's an inspection, but they put a dollar cap on the inspection of like 5,000. And then radon came back and was at an elevated level. And the listing agent said, oh, well, you're not over the 5,000 threshold. And the buyer's agent adeptly said, that's a separate contingency. So we actually have a radon contingency. So if you're seeing G-Bar offers, just be aware of that.
Yeah, I was going to say just two things, Brad, just to add on to the as-is business. That provision in the contract is usually housed in with the provision that says you've had the right to have an inspection, you either had it inspected or you waived it, and now you're buying it as is. So that's, you know, those two things sort of dovetail. And I do like what Brad said about maintaining the right to back out. But another thing that I've found that buyers think they really mean when they're saying for informational purposes only is they're not going to nickel and dime the seller. So what I've seen that people have done is set a cap. They'll say, you know, if it's a $10,000 concern or a $5,000 concern, you know, then we'll talk, but anything less than that. And I understand that that opens up the floodgate to, well, you know, we want more windows, and these windows are going to be pricey. So another person suggested capping it at, you know, structural and systems. So I would say if you really, if the inspection is truly for informational purposes only, you can do it after you buy the house. I mean, from a seller's perspective, right? If it's truly for informational purposes only, but yeah, just to speak to the point, clarify, write it so it can't be misunderstood. And, you know, say that if you want to be able to back out, you retain that right, or cap it at what the concerns are going to be that the buyer may have.
I'm going to continue to belabor this point, if you don't mind, for 1 second, because I think it is, as the gentlemen have already said, that as is, aren't all inspections for informational purposes? I mean, why else are you doing an inspection? I mean, so the one part of the G-Bar form that I do prefer is in the contingency addendum. It does say, it has that cap language. It says, if the inspection exceeds, you know, finds problems in excess of, and there's a number, you know, there's a blank, for mechanical, plumbing, blah, 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 blah. Go rip that language right out. Listing agents, you need to, you know, sometimes be the parent in the room. If it says as is, you go back and define as is. For informational purposes only, also 100% I'm with Mike Baird. If you say for informational purposes only as the listing agent, I would say, great, you can do that after the P&S has been signed and you have some real skin in the game, not $1,000. Now, granted, buyers might walk over that. But or after you've bought the house, because what is an inspection really? It's almost like you're going for your annual checkup. Blood pressure's a little high. I need to lose a few pounds. Like this, you know, if honestly I don't, you know, have a major problem. Okay, you have a diagnostic of the house that you're buying. What should you look at the next year, 3 years, 5 years? Roof looks good. It's brand new. So define what that is, because if not, then us attorneys are all trying to say, no, this is what my client meant. No, that's not what they meant. And also when you're saying the as is in the listing, just like when it states that seller needs to find suitable housing and then it doesn't get into the offer, and then us attorneys are like, well, wait a second, because, you know, we don't have to go look in MLS. So it needs to be contained in the offer. And then, you know, and then what is the question? is the buyer able to walk after that home inspection and get their money back? I think the majority of us, if it just says as is, would say, yeah, you can have your money back. But is that what the seller's expectation was? And then, you know, all the way back to when we were talking about like waiving the home inspection, Catherine's point of you guys, the agents have to memorialize what's going on. I do have one agent right now that's being sued because she said that although I know this agent very well, she would have never said waive your home inspection. It was, here are the things that you can make your offer more competitive. One of the things you could do is waive your home inspection. And then of course, buyer bought the house, has found problems. You told me I had to waive. And it's like, no, this is the game that we're playing. Here are the rules. Would you like to play the game? And so this agent was like, can you write me up something that like disclaims any sort of liability, you know, and everything else like that. And I said, I could draft something, but it's more important to just have it in an email or have it in your, you know, initial discussions that these are what you can take off: appraisal, inspection, mortgage. Let's talk about it. Let's talk about what approach you're going to take. Maybe it's a case-by-case basis. Maybe it's never a case-by-case basis. You're in a market or a price point or something where you know it's going to have happen. But you guys need to protect yourself. And with these inspections, what Catherine was talking about earlier with the love letters is, you know, if someone sends you an inspection and it's the entire inspection as a listing agent, you do not want to see that. Once you know, you have to disclose from an ethical standpoint, from a realtor standpoint. So therefore, if the entire inspection is sent to you, you very quickly, you send it back. I'm sorry, thank you very much. I did not look at this inspection. I have deleted this email. I've emptied out my deleted file folder. Please send me the pertinent portion of the inspection of what you are looking for us to have done. I don't want the entire inspection. And make that very clear. And then again, protect yourself, memorialize. I didn't ask for the whole inspection. I wanted the thing about the hot water tank or the electrical panel or the whatever else like that, because the agents now, I am seeing a lot of lawsuits coming up about people threatening, what did or didn't you know? Why didn't you go look at permits?
Yeah.
Why didn't you go do this? Why didn't you go do that? Well, this market is moving extraordinarily fast. The market's coming, if it's coming on the market sometime on Thursday and offers are due Sunday or maybe Monday, now it's summer, the town halls are closed on Friday. You couldn't look at permits. Like, so are you
Right.
educating your clients that we do not have the time to do the due diligence that we normally would, and I need you to appreciate that it can't be done. So not only are we maybe waiving inspection, we're maybe waiving some other due diligence that I would, in a normal circumstance, recommend for you to do. Because again, these permit things and like all these other things, I'm starting to see buyers get very litigious because they felt pressured. It was emotional. There's a lot of money. And now 2 months, they're in the house and they're like, well, who exactly, as Catherine said, there's someone's paying me something. So it's going to be the attorney missed it. My agent missed it. I'm going to sue both of them. And then I'm going to sue the listing agent for not disclosing. Then I'm going to sue the seller. I mean, it's going to get ugly out there, I think, in the next 2 to 3 years as things come up, and then we get into foreclosures and everything. So keep fleshing out as much as you can. Use additional sheets in your offer. It doesn't have to go on those 2 little lines. Use an addendum. Use all the forms that are available to you in MAR, and really make sure that it is clear so that we have a meeting of the minds.
And even though there's no form for waiving of different contingencies in MAR, I really encourage everybody to speak to their brokers, about their needs, because that's something that you, as an agent, can get, with your broker. Okay, let's go on to back in the chat. We had a question for some guidance on working with multiple buyers who are making offers. So you're a buyer agent, you've got more than one buyer interested in the same property, and making offers simultaneously. So some recommendations on best practices for how to do that and keep yourself on the right side of things. Anyone interested in tackling that one?
I'll kick it off. This is another one of those questions that, because of the marketplace environment we're dealing in right now, I've been getting a lot of people asking whether this is appropriate. It is. Our license law does not speak specifically to this situation. It does not constitute dual agency. There's no required notice or disclosure consent required for representing two buyers who are interested in the same property. The thing to keep in mind is, what are your fiduciary duties to each of those clients, and can you fully fulfill those fiduciary duties? Number one, confidentiality and loyalty to your client. Can you fulfill those if you're representing two people competing on the property? I think human nature makes that extremely difficult to accomplish. So depending on your office setup, there are a couple of different avenues you could take. I would always start with a conversation, even though the law doesn't necessarily require you to disclose it or receive consent. It's going to be a good business practice to talk to the buyers at your initial meeting and say, listen, because there are so many buyers and so few properties for sale, this is a potential situation where I could have multiple clients who are interested in the same property. If this happens, what are you comfortable with? Are you comfortable with me working with you? This is what I will do to ensure that I'm continuing to fulfill my duties to you as my client in this situation? Or would you rather I refer you out to somebody else, either within your office or within another office? You can certainly do that, and you can, have a referral relationship to send somebody out for a specific property. Again, it's not required. And the other thing I would say is the MAR exclusive buyer agency form does have a line in it that specifically speaks to this situation. If you are using a buyer agency agreement, I would spend an extra couple minutes and highlight that fact, just so you're having that conversation so that they're aware of it. Again, transparency is going to benefit everybody. And this is more of a business practices question than a legal question, because from the law, it's fine as long as you're fulfilling your fiduciary duties to each client. From a business practices standpoint, you might want to handle it a little bit differently.
Thank you. Okay, escalation clauses. So there were a lot of questions came in ahead of time about escalation clauses, but they pretty much boiled down to, what are just some of the pros and cons on the seller side, the buyer side, what to look out for, what could, potentially be some pitfalls. So just looking for discussion on that. Mike, I could tell that you wanted to answer this.
I was leaping forward to answer.
That's what I saw.
I mean, the buyer makes an offer for $350,000, right? But they're willing, the buyer is willing to go as high as $375,000. How much has the buyer offered to buy that house? $375,000, right? Or, in the legal line, $350,000, but the seller knows the buyer is going to go to $375,000. What should be clarified is under what circumstance the, that escalation clause kicks in. So there's a lot of things to take into consideration. So as the seller, if you see this, think about, before responding, or as the listing agent, think about what the seller's obligation is when they sign that offer. So if the seller signs an offer, how are you marking it in MLS, right? Is it under agreement? If you have an escalation clause, does it get marked in MLS in a different way? Is the seller now okay to continue to, to market the house? Are you going to keep having open houses until a certain point? Okay, so that's one consideration. Another consideration is, at what point does that escalation clause die? So in other words, does it survive to make it into the purchase and sale agreement? So now you have this escalation clause over the buyer's head between purchase and sale and closing. So again, I would clarify with your, with the other agent, or with the buyer, with the seller, and say, when does this escalation clause go away? When does it stop? If the seller can seek other offers, actively seek other offers, does it die between offer and P&S? And now the P&S is for the, for say the 350 in our example. That's, you know, that's the way that I would attack it, again, with communication and clarity. The other thing to remember is with respect to an estate, a personal representative of an estate always has a fiduciary obligation to get as much money as they can for that property. So that you know, you want to spell that out as well in terms of the buyer having the ability to match any offer, and you want to lay out those mechanics to, you know, when to, if the personal representative is going to get other offers, how they're going to respond, and how that back and forth is going to go. And the buyer may or may not have the ability to respond to that. But again, just I would clarify when it dies, the escalation clause, and how it gets enacted by the seller to now somehow demand, you know, more money.
Those are good points, Mike. One thing on that I advise people to write in is just clearly that this buyer's willing to pay up to X amount of money and will pay $1,000 or $2,000 more than the highest bona fide offer proven in writing, personal information redacted by the listing agent. So that way you've got a cap. I have had situations, unfortunately, because we're not involved in the offers. I've had situations, unfortunately, where the listing agent providing proof of the highest bona fide offer that we were going to escalate off of was not in, and their contention was, we're just going to tell you what it was. I'm like, okay, this is ridiculous. You know, I'm sure it was 10 million, right? So just make sure you write that in so there's no confusion, because unfortunately in that situation, it was days of back and forth until finally the listing agent relented and gave us the redacted offer, which was in fact matching what she said, but it wasn't helping everybody's trust that it wasn't being provided. So that's just a tip in that regard. My contention on the escalation, and a point well taken on probate and what have you about having the right to get a higher price, but usually the escalation is going to cease when the offer ceases, because it's part of that offer. So if my offer is good until tomorrow at noon, and I have an escalation clause, once that offer is accepted, then we're done. That escalation clause dies with now the accepted offer. So there's nothing else that needs to be written in. It's up to the listing agent to have a competitive market where they're trying to maximize price and to have other bona fide offers that will cause my escalation to have to go up. But that would die when the offer is not countered or expires.
So I would say this about escalation clauses, and I did not like them when Brad started slinging them on the South Shore, but it's he created that market on the South Shore, I'm convinced. And you know, I didn't trust it.
Occupancies too.
Yeah, that's what I heard.
He you know, I didn't trust the process with it. But, you know, at the end of the day, it's another strategy. If that makes your buyer comfortable, it's a strategy. It's something that you have in your tool chest that you can present strongly with a seller who now, thanks to Brad, has recognized and understands these escalation clauses and understands their duty to provide proof, bona fide proof that, you know, there is an offer, but let's accept it. So many strategies out there. I love Carla's strategy. The best so far of what I've heard today is having the agent send the agent the love letter and fill in those blanks, fill them all in, and, you know,
So
make
I
it
want
an
to
experience.
take a couple things that I've heard and add on. So first of all, escalation clause, what are the terms? So is it just, I mean, what if you have a $350,000 purchase, they've waived everything. Then someone else comes in with an escalation clause that has an inspection, a mortgage contingency, and an appraisal, but they're willing to pay up to $375,000. Those are not the same offers. So is it just terms or is it just price? Because I could see a buyer coming in saying, I was willing to pay more and you accepted this offer, but why? And then all of a sudden I'm going to sue you because you didn't accept my offer. So is it just price or is it terms and everything else like that? Number two, agents, if you're going to send an escalation clause, are you sending a new pre-approval up to, you sent the pre-approval for $350,000, did you send the pre-approval for $375,000 that you're going to, because an agent, you're looking at 40 offers. Listen, I know agents who are like, you didn't sign the lead paint form, I'm putting your offer aside. You didn't do this, I'm putting your offer aside. Pre-approval isn't here, that's matching the price, I'm putting it aside. So make sure that you are giving them, again, everything that they need to accept your offer. And then someone asked, can an agent say we're not accepting escalation clauses? Yes, again, put it in MLS. We will not accept escalation clauses. Then the fourth point is that I've had people call me up and go, is this legal? Is we had an escalation clause that said we will beat any offer by 1,000, 2,500, 5,000, whatever it is, up to X point. Then they come back, the listing agent comes back and tries to start negotiating from that point. And they're like, but I already gave my highest and best. Why are they negotiating with me? And I'm like, it's not, I don't think it's good practice, but they can still do whatever they want. It's still the seller's house. We can still negotiate. So even if you said you'd go up to 375, they'd say, listen, we had another 375 and we'd like to go with you, but will you give us 380, sort of thing. So is it legal? Yeah, it's legal. But if you're gonna, again, every single time that we put a wrinkle in how are we gonna get to the finish line, it needs to be thought out, it needs to be spelled out, it needs to be communicated well. And this is, again, buyers agents and listing agents, this is a negotiation. So don't just quickly accept it without getting everything memorialized in that offer, because by the time it gets to us attorneys, we're almost sudden unraveling the entire deal to make sure. And then on top of that, you've given us almost unrealistic dates that it's like, hey, today's June 3rd, we're going to close June 30th and we can have a signed PNS by Friday, right? And you're like, well, now we have to undo this entire offer. And your client just gave notice, so they need to be out July 1st. And the loan officer also said the appraisal is going to take 3 weeks. So we can't meet any of these dates. And everyone's like, well, where am I going to sleep that night? And I'm like, well, potentially some conversation should have been had with everybody. And I get it. You're trying to make the offer as competitive as possible. So you're like, hey, buyers or sellers are going to have to pay their mortgage payment next month. So let's get this, let's get this done. But I keep saying to agents, where's the fire? You guys are creating the fire. So unless your seller is like, I need to be in Florida by August 1st and I need no mortgage payment. Okay, there's a fire, but let's stop creating these artificial fires that are just causing massive problems for everybody. I was told by one of my top movers the other day, he said, hey, by the way, we're completely booked for June. We do not have another opportunity to schedule another mover. Yeah. What? So what about all these people who I'm still getting offers that want to close June 30th? Who are their movers going to be? So,
college kids.
Right. So thoughtful consideration about all these numbers and dates and, everything else like that before we create a fire that's maybe not necessary.
Have any of you seen escalation clauses without a cap? I know that I have.
I would just say, I would just sort of bring it back full circle and say, under what circumstances, does the escalation clause kick in? So under what circumstances, and write it so it can't be misunderstood. The seller, in the event the seller presents us with, a bona fide offer redacted for X price, the buyer will respond in 2 days, and the terms matched, like Carla said. Really, just work out the mechanics of how that conversation is going to go.
But how could you look at an escalation clause that doesn't have a cap unless they're giving you a pre-approval that is, has,
As a
really
listing,
can't happen, right?
as a listing agent and a seller, I would say take that for what it's worth.
Yeah.
Really.
I think part of the questions, and there was another question in the chat about, and this happens all the time, you have multiple offers, you have multiple, just hang on one second. We're going to have to say goodbye to Mark because he has an appointment at 10:30. And thank you. Thank you very much.
Thank you all for inviting me. I really appreciate it. I love learning. One thing I will leave you with again, Mar, Catherine Taylor, lean in, get that information, get that comfort level, and make sure all of the agents are getting the good CEs that South Shore is providing for everybody, because it's an ever-changing market. It's really moving, rapidly, and it's important that everybody's got their knowledge and and those E&O policies up to date. But thank you. I appreciate you. And thanks for letting me
Thanks for
stay
coming.
early. All right.
Giving
Bye
us
now.
your knowledge.
Bye, everybody.
Bye.
Bye.
So, okay, so you're a listing agent and you have 30 offers and 10 of them have escalation clauses. So this question is about, you know, how to handle these, you know, escalated over, you know, other escalated, and what advice do you have for that? And, you know, what can you shed any light on that?
I'll kick that off. And I do want to just point out, MAR has a form which I'm obviously partial to. It's called Escalation Provisions and Offers. It's a 2-page form, and the whole first page explains how escalation clauses work. It explains the terms it needs to include. It goes over the pros and cons of it. It's not a one-size-fits-all. So if you are not familiar with that form, please take a look at it. And then the actual escalation clause itself is a whole page, and it spells out what increments it will go up in. It includes the cap. It includes the process for documenting the competing bona fide offer. It documents how that escalated price will be covered. Is it going to be finance? Is it going to be cash? Is it going to be a combination? And then it says that once that escalated price is accepted, that becomes the terms of the offer, and the escalation clause then dies. It does not survive to the PNS. It's just that price. So it basically operates as a counter offer. You and your sellers don't ever have to use an escalation clause. Just like any other term in an offer, it's negotiable. So if after seeing this, or in that situation where you receive 10 offers that all have competing escalation clauses, it can get really confusing. But it all still boils down to, what's your seller's instruction to you as a listing agent of how to handle those? You can obviously have those escalation clauses bouncing off of each other. If you're doing that, create a spreadsheet. Otherwise, you're going to go crazy, because it can get very complicated very quickly. Your seller can also choose to negotiate with one of those offers. Your seller could also choose to go back to all of them and say, just give me your highest and best. Don't include an escalation clause. Or they could say, okay, these 10 offers, one goes up to $390. That's their cap on their escalation. I'm just going to counter them at $390 and forget all the rest of these offers. So there are a lot of options which you as brokers and agents need to make sure that you're familiar with, so you can counsel your clients to help your clients make that best decision for themselves. You don't want to have an agent or office policy that says, I don't do escalation clauses, because then you get to that question of your fiduciary duties again. Are you fulfilling your obligation to your client by not engaging in this process, particularly where it is so prevalent in the current marketplace? So educate yourself so you can educate your clients to make the decisions of how to handle these situations.
Chris Head is asking if you can elaborate on this provision, but I'm not sure what provision.
Perhaps the escalation clause, because it's called Escalation Provisions and Offers is the name of the title. It's available in our forms library. And I think it's pretty explanatory once you look at it. It walks you through and includes all of those terms that you want, particularly the increments, the cap, and the financing piece of how that escalated price is going to be covered. And then the other thing I do want to touch on escalation clauses is that one of the questions I receive frequently is, well, aren't the terms of my offer confidential? How can they use my offer to negotiate with somebody else? Your offer is not confidential unless there's been a previously agreed upon confidentiality agreement between that buyer and seller that says the terms of their offer are going to be confidential. You can't submit an offer and say it's confidential, because it's not an agreement. It's just you saying it's confidential. So if you want your terms to be confidential, you have a client who wants them to be confidential, call up the listing agent ahead of time and say, is your seller willing to enter into a confidentiality agreement? For whatever reason, there may be situations where it's appropriate, but 9 times out of 10, possibly more, it's not going to be confidential.
Chris clarifies paragraph 3, apparently, of the MAR escalation provision.
So I'm sorry to say I do not have the form memorized and I don't have it in front of me, but if you give me a minute, I can pull it up and take a look if anyone else wants to touch on it. Or you can call the legal hotline and I'm happy to talk to you about it later on today.
Well,
I
Mary,
think,
oh, sorry, go ahead.
I was going to say to your point, Carla, that, you know, part of the questions that came in about escalation clauses, about, you know, pros and cons, and Carla definitely touched on this. If you have an offer in with an escalation clause, you could be escalating over an offer that is not necessarily that great in its terms. If your offer is escalating, it's about the price that you're talking about, and you could be going up to, I think in your example, say you were going up to 400 and you have nothing to sell and you're going to close whenever the sellers want to, and maybe you have even waived your home inspection, et cetera, et cetera. The second best offer could have a house to sell. They could be doing a home inspection. They could have a very rigid timeline for, you know, for closing. So I think that some of this, you know, in addition to what's allowed and what's legal, and, you know, Catherine, as she's addressed the form, which is great, you know, there are other considerations that obviously as a buyer agent or a listing agent, you have to be aware of, mindful of, and thinking through of whether it's the right avenue for your client.
Can I say one thing? And I know that it's going to get us there, and Catherine might want to answer paragraph 3 first, but we only have 24 minutes, so I want to say it, is that the minute we have escalation clauses, the minute we have 50,000 over asking them, guess what needs to go away? Appraisal contingencies. Because the minute you're saying, I'm going to pay $40,000 over the best offer, so it's not even over asking, it's over the next best offer. Oh, but I'm going to keep an appraisal contingency. Well, guess what? You might as well say, I'll pay $200,000. Like, it doesn't matter. Like, let's just start making up funny money numbers, because the appraisal contingency language needs to, and I think it's the bane of my existence right now is this appraisal contingency language. But it's like these things also start getting tied to all of these ways that we're trying to manipulate the numbers to make the offer most attractive. So Catherine, if you have paragraph 3, we could go there, but then I feel like with this whole conversation, we need to go to the appraisal side.
Oh, well, that was almost next on our list, so good idea. Catherine?
So yeah, I'll just touch on paragraph 3 quickly. That is the paragraph that talks about the process if the offer price as escalated is accepted. And it simply requires the seller to provide a counter offer within 48 hours, and it obligates the buyer to sign that so that it's all incorporated into one clean agreement that has the escalated price as agreed upon, so that you're not dealing with multiple moving pieces. So that's what paragraph 3 is. Again, that's available to all of our members through our forms library. So take a look there, and I'm happy to answer any additional questions. If anyone wants to call the legal hotline, I did put it in the chat box at the beginning of this meeting. So that's the legal hotline phone number. Certainly feel free to give it a call.
All right, so our next topic actually is financing contingencies and appraisals. And so basically, what Carla just said, you know, a lot of questions revolving around what language is best to use to address concerns on gaps in appraisals, what to be aware of, potential issues, the difference between a financing contingency, like this particular question was, if a buyer waives their financing contingency, do we still need to have any concern over the appraisal? So just lots of questions about that in general. And Mike, I know you like this topic.
Thank you. So the question is, if you've waived your financing contingency, Can you still require an appraisal?
No, they're just, I think this was from a listing agent's point of view, reviewing offers. And, you know, some of them are high, like Carla was just saying with these different escalation clauses. As a listing agent, if somebody waived their financing contingency, can I stop worrying about the appraisal? Or is there some aspect that I still need to be concerned about?
I guess my knee-jerk thought is yes, you can not necessarily waive, you can not necessarily worry about the appraisal unless it's a cash buyer that adds an appraisal contingency. So it could be a cash buyer who still wants to make sure that the house appraises. That those two contingencies can stand apart. They often dovetail with each other because in order for the bank to lend on property, it has to appraise for the price. So in order for the buyer to borrow a certain percentage of the purchase price, it has to appraise for something. You know, it has to appraise. Typically, those two appraisals, those two contingencies dovetail. But if you're going to waive your financing contingency outright, then essentially that appraisal contingency is not housed in there, unless you say in the offer, you know, I'm a cash buyer, I still want the house to appraise, I'll still pay, you know, the price for it, but I am ultimately not getting a mortgage.
Okay. Brad, what about appraisal gaps?
I had my hand up. You guessed.
I
So
know.
look at that. So this is a big issue. I think. I think there's whether or not financing and the appraisal as an out in the contract or interlinked depends a lot on the type of loan. You know, everybody can talk out of both sides of their mouth on it, but I always say this to the clients and attorneys and agents: if you're putting 30% down and you don't, and it's a very competitive market, and we all know that there are times in offers agents will put in subject to the appraised value matching the price, okay? And if you're in a competitive market and you have a mortgage contingency, but you leave that language out, my argument is it's okay for the seller's attorney to put in language, which we do, that the buyer represents that their ability to perform is not contingent on, and we usually put if there's no home sale contingency, not contingent on selling any real estate, nor on the appraised value of the property being equal to or greater than the price. Buyer acknowledges they have the funds to make up the difference if the appraised value is less than the purchase price. That to me ferrets out any confusion. Now, if there's going to be an issue and that's not the understanding of the buyer, their attorney is going to come back and be like, no, they're getting a mortgage and the appraised value has to be equal to or greater than the price for them to qualify. I'll counter that and say, okay, well, show us the pre-approval that was submitted. There were 12 other offers. Why didn't you put in an appraisal contingency into your offer? Because now you're actually putting one into the purchase and sale, and that's going to have a big impact on whether or not the seller wants your offer. So I think the understanding and the takeaway is, in this market, if you're one of 12, which is very common, and you're over asking or you're willing to pay over the list price, you've got to be aware, or your client's got to be aware, unless it's a VA loan or unless it's an FHA loan, they're probably going to be waiving their appraisal contingency, and they have to be okay with that, meaning that if the appraised value is less than the price, the buyer has to understand that they have to make up the difference between the price and the appraised value to go forward. If they aren't willing to and try to use the appraisal as a reason to cancel because of the mortgage contingency, there may be an argument over their deposit.
See, we Brad, and you and I have obviously discussed this before. But see, I think that if in the offer you don't specifically waive your appraisal, then that appraisal is part of the financing contingency, unless you've said explicitly the buyer hereby waives the appraisal. I would say that if the offer is silent to it,
I disagree. Yes.
I
disagree because
I think
I disagree.
Tiebreaker.
I disagree because why do people put in why in a normal market do agents put in subject to the property appraising at the price?
bells and
I think
suspenders,
what
I
it
guess.
is that
I
Mike
don't think they need to.
Mike is on the school of the agents don't realize, and so they're not putting it in. And the meeting of the minds, because I know Brad and I have gone back and forth about this. I'm like, that is not what my client thought. My client had no intention of waiving their appraisal contingency. And Brad's like, of course they did. And I'm like, that is not what they thought. And so I'm on Mike's team in the sense that I don't think that the agents nor the buyers think that that's what they did. Am I on Brad's team that I think that that's what the listing agent and seller thought they did? 100%. But this is why it's the bane of my existence, because it's unclear. The attorneys are trying to flesh it out in the P&S, and they two attorneys. And trust me, when I'm on the sales side, I'll say the same thing as Brad's saying. But the fact of the matter is, the buyer never thought they were waiving it, because I tell people, I say, if you're waiving appraisal, you write in waived appraisal. If you're not waiving appraisal, you write in subject to appraisal, or subject to, let's say it was 350 and we're paying 375. It had to at least come in at 340, or something like that. You've got to have a meeting of the minds at the offer, because if not, again, 3 days later, we're all fighting about it. And now we've lost 3 days. And then on top of that, did the listing agent do their job? First of all, did they show the funds that if in fact the buyer said that they'll make up the difference? Did they see the funds that they have it? And then on top of that, did they call the loan officer and say, hey, I see that they have an extra $20,000. Is this $20,000 what's approving them for their loan, that if they used it for the appraisal, they don't have the reserves they need anymore? So the minute we get into all this appraisal language, there is a much level higher of duty, investigation, fleshing out that needs to be done, versus just like, oh, yay, this is what I think's happening. And now all of a sudden we don't have it. So I think that Brad and Mike are both correct in the sense that each side thinks something completely different.
Yeah, and I go to this point on this. If you have 12 offers, and again, this is $1 million house, let's say. There's cash offers and there's 30% down, 50% down. Do you think you would have gotten the offer as the buyer and buyer's agent if you put in subject to the property appraising at or above the price? Answer's probably no. So if it's silent on it, you can expect the other side, seller's attorney, to write in language that says you acknowledge that the ability to perform, even if you have a financing contingency, is not contingent on the appraised value. The way to make this, to Carla's point, to make this much easier, and I think we've seen an evolution as this market has continued to be ultra competitive, is for the buyer's agent to talk to their buyer, and even if it's a financing contingency, write in, buyer agrees to make up the difference between the appraised value and the price. And then it's right there in the offer. Everyone understands, and there's no 3 days of fighting over the purchase and sale. Again, it's less than 20% down. There's an argument they don't have the reserve funds. I'm not trying to be difficult. I'm not trying to pinpoint things, but if you have a pre-approval letter that was also submitted with the offer and it doesn't list the appraisal as a contingency, there's just more proof for the seller side that we're very, very competitive market. If you'd put in an express appraisal contingency, we never would have accepted your offer. So don't try to put it in now or to not have it clarified in the purchase and sale. And hence, that's why I think better language in the offer takes away any of these arguments and has a meeting of the minds.
Mike, do you have something else? Because if not, I'm going to address Chris Heath's question. Why would you?
No, please, I think that we've spelled out the counter arguments pretty clearly. I do say that if I do like the idea of capping the difference of what the buyer is able to make up, because a lot of times I talk to the buyer after the fact. They say, yeah, I can come up with another 20, but not another 50 if the place doesn't appraise, So yeah, so have those numbers really fleshed out, and yeah, we can definitely agree to disagree.
But great point, Mike, on that. Put a floor. So it's like, listen, if it's $1 million, be like, buyer agrees to perform if the appraised value is $990 or above.
Yep.
That way, like, that's in there, and that just gives the buyer confidence. Okay, at least I have a floor. Or, say the listing was $950 and it went for $1 million in a competitive situation. I'll see a lot of times, a buyer will perform if appraised value is listing price or above, $950 or above, things like that. So just every deal's different.
Yep.
So Chris, to your point, so first of all, just because you waived your mortgage contingency or your appraisal contingency doesn't mean that most lenders, unless they're doing a desktop appraisal, they still have to have an appraisal. Even if they said they waived everything, unless they specifically said it was cash and they showed you, Not only that, but even if they said it was cash, there's still, I mean, if you have the access language, which is in most PNSs, they could still say, hey, you know what? Rates are so low. Why would I buy cash? I'm going to go get, I'm going to go get a 2.5% 15-year ARM or 10-year ARM or whatever. And I'm going to go ahead and I'm going to get a loan. So just because they waived it doesn't mean that they can't still have an appraisal or anything else like that. It just means that their entire earnest money deposit is at risk if they don't do what they said they were going to do in the offer/purchase and sale agreement. So yeah, an appraiser should still be allowed access to the property. A home inspector, if you waive the home inspection and then they try to get in or something, that could potentially be a different conversation. But I would say the appraiser can still have access to the property.
That's an excellent point. And I would add to that, even if you don't have a financing contingency, if your buyer is still getting a mortgage, TRID rules still apply. So it's not unreasonable for a buyer to put in something that says that we're going to
I disagree
with TRID regulations.
Joyce disagrees with him too. Joyce will never let me have TRID language in if it wasn't in the offer.
If there's the waiving the mortgage contingency, I don't allow TRID language in. And
yeah, well,
I think the cash, is it cash or is it cash? So people will show funds and say my client's paying cash. Yeah, so is it cash is we have the funds, but we're getting a financing, so we need access and things like that, which is fine. But the problem is you have a situation where you've got sellers who are like, why did I get a call? Why is the listing agent calling me to set up a time for the appraiser? This person's paying cash. That can sow mistrust, confusion, what have you, when it's very, very common. And again, that's just the buyer's agent to the listing agent. Hey, listen, here's the $1 million, but they are going to get financing because money's so cheap right now. So that's easy to get over.
Well, it's interesting to see all these, different opinions. We have not a lot of time left, of course, and we have a couple of subjects that would probably take a whole nother session, but I guess we'll take a stab at a few of them. One was just escrow deposits, and are you seeing a lot of disputes over escrows, and if a buyer backs out, can't perform, what are you seeing? Are you seeing sellers keeping deposits or negotiating something out? So just kind of a general question about what you're seeing in your businesses.
There's always the threat to keep a deposit. And then they realize that they're gonna, the thing that gets some people is the way our contracts are written. Usually the listing agent's the escrow agent, right? So the way the contracts are written, deposits cannot be released except for mutual agreement of buyer and seller or a final court order from a court of competent jurisdiction, unappealable final order. So what that means is even if the buyer is absolutely in default, like I'm not buying your house, I have no contingencies because I don't like your house and I want to buy the one next door. Even if that's the case, the listing agent as escrow agent can't just release the money to the seller. And that frustrates sellers. Like, well, why do we have that? Well, we have that because if we didn't, we'd have competing interests where it's like, they're in default, give me the money. And the buyer might be like, well, I'm not in default. So are we seeing it? We're seeing threats of it. I've seen, I think, one, and it got referred to a litigator, and I think it was settled. They split the money in half. So that's all I've seen over like the last year. Nothing, a lot of threats of it because it was waiving contingencies, but at the end of the day, a lot of sellers want to sell, and that means right away. And that the threat of a lis pendens and 20, 30, 50,000 in litigation just causes them to say, let's come to a deal and move on.
I don't think any of the attorneys, nor Mark when he was here, would ever advise our clients, I don't care how in the wrong the buyer is, to keep the $1,000. It's just, it's not worth the hassle. The second deposit, yes. Do we see a lot of threats? Absolutely. Do we, what is it, $7,000 in small claims court? Almost every deposit is over that. So you're going to real court, like court, not small claims court, to fight over this. So you have to all of a sudden take attorney's fees into account on that. And then additionally, I get a lot of calls, which could be a whole nother thing from agents, like, can we put it back on the market? Can we not put it back on the market? If the buyer wants to buy and the seller for some reason wants to walk, you absolutely cannot list that house again. Like, there's no way. They have a right. There's lis pendens possibilities and everything else like that. If the buyer absolutely does not want to buy and has made it abundantly clear, I'm not buying your house, take your house, sort of thing. Can we relist the property? But you haven't released the deposit. Well, the question becomes, yes, you could, but then when us attorneys put in the language that says, is there any pending litigation, seller has no actual knowledge of any pending litigation, da, 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 da. We can't represent that because the buyer very well may be ready to sue. They don't want the house. We're not talking lis pendens, but they're very well may be willing to sue over that. I've only once in my entire time, and it was over $150,000, and it had every reason to go to court. Had anyone actually go to court over a deposit? Usually, as Brad said, somewhere along the way, calmer minds prevail and they end up splitting it.
On that point, Carla, we do see this where even on an offer stage where a buyer just flakes and they're like, I'm out. I'm overpaying and I'm not buying it. And then the agent comes and says, well, can I list it? I'm like, well, problem is you guys signed an offer. They did give the 1,000 and we have a purchase and sale signing date of whatever, 3 days from now. And now the buyer's ghosted everyone and is not signing a release. What do you do? So it's like, well, we got to wait at least until we don't have a purchase and sale. And then there's an argument if the buyer was really crazy that they got McCarthy v. Tobin and they're going to enforce an offer. So what are you doing over this stupid $1,000? Like, do you wait until the closing date in the offer is over to be really, really certain? And you probably have to think about that if you are relisting it of when am I going to close on the other property? Yes, there could be pending litigation.
But my question becomes, you're right, an offer is a binding contract, but if there was an appraisal contingency, or if there was, not appraisal, mortgage contingency language, well, the fact of the matter is, and granted, they could always buy it cash, which is why you can never sell it until the day after but the fact of the matter is, like, if they don't do any of their due diligence to further it, and I don't know a single lender out there that will give a loan based upon the offer when the offer states we're going to sign a P&S. So this is, agents, why this is not an easy answer for us attorneys, because every time we're like, well, we got this, it's like, well, wait, we got this, So the fact of the matter is, just don't keep the money. I mean, I hate to say it, I always tell people, do you want to be right or do you want to effectuate what you actually want? Because oftentimes you can't do both.
And on that point, we just talked about it is kind of illusory to have the 1,000. I think that's why it's more and more common now. At a higher price point in the market, you're seeing 10,000 and 25,000 as the offer deposit because it's real skin in the game. It's not just a free look.
Right.
Also keep in mind, sorry to kind of belabor it, I know we're running out of time. Also keep in mind that if the seller is going to try to hold on to that deposit, there's a school of thought that says the seller has to have performed. So that means that attorney brings the deed to the registry of deeds, pages the buyer a few times, you have a record of that, the house is vacant, broom swept condition, ready to be delivered, and then you can start to dance about the deposit. I've only had to do that twice in my whole time. But yeah, I would just kind of add that the seller has to be ready to perform in order to.
Well, I think that part of this question as an agent, when you're in the field and you're counseling a seller, typically you're kind of laying out what's going to happen and, offers and whatever. Usually what I find is the seller says, oh, so then if they don't XYZ, meaning the buyer, I keep their deposit, right? I would say 99% of the time, that's the question that comes from the seller. So I, of course, am never going to say yes or no. And so I typically say, well, their deposit, the buyer's deposit is at risk. I mean, that's usually what I say because I think that only twice I have ever had a seller keep a deposit, so I feel like it's not that common. And, when it happens, it's usually for, a pretty strong reason. And so I think part of this question was about, as a listing agent, what do I say? I don't want to be representing that, sure, you've got this deposit money and maybe it was 10, 20, 30, maybe it isn't $1,000. And the sellers are kind of seeing those dollar signs in their eyes, that's something that they might be able to, to keep. And that's not, I think you've made it clear that that's not always the case. So
I'm just going to hop in with one last point because I think that everybody else has made excellent points. And I think this underscores what was said earlier, that the earlier in the transaction your clients can get matched up with an attorney, the better it is for everybody. because these are the types of questions that you as realtors should not be counseling your clients on, because you don't want to give them legal advice. You need to be able to say, go talk to Carla, go talk to Brad, go talk to Mike, and have them counsel you on what needs to happen in this situation. You know, but if they don't have an attorney at that point, then you're stuck in this delay situation that just prolongs everything. So work with an attorney, tell your clients to get attorneys, don't give legal advice.
That is very good advice from you, Catherine. So we're going to have to say goodbye and thank everybody. So just to remind you that you as brokers, yes, can reach out to the hotline and ask your questions from Catherine, and Marie at Social Realtors put all of our panelists' contact information in. You know, they're all Social Realtors affiliates, you know, great attorneys that you can all suggest to your clients and get answers from, and involve yourself in some of the other learning opportunities that they have. So I know we ran out of time, so Carla, you didn't get to talk about suitable housing, your favorite, and Brad, you didn't get to talk about use and occupancy, your favorite, and you know, on and on. Solar panels, that was another one. So maybe we'll have another one of these, and maybe it'll be in person, which would be great. But thank you, everybody, and have a great rest of your day.
Thank you, everyone.
Thank
you.
you. Thanks,
Bye.
everyone. Bye.
Thanks, Mary.
Thank you.
Thank you, Mary. Thank you, Catherine.